tomorrow.
Why?
My lord, what are some instruction as required, my lord. That is it. I have taken the consent of other side.
What instruction is required?
Day after tomorrow or 9th.
There is a notification issued by this
Yes,
court.
my lord. On 19th or 18th.
Right, on the prayer made by Mr. J.M.A. Chaudhary, this is the matter on Thursday. No, on Friday. Wednesday, sorry. Yes, yes.
Paper books, my lord. This is
Not paper book. Give your IA copy
IA.
today.
Okay.
Mr. J.M.A. Chaudhary shall provide a copy of the IA to Mr. A.R. Talukdar, Learned Counsel for the point number 2. Today.
Public.
Okay.
Wednesday, Wednesday. Yeah.
Clearly, the laws, I beg to mention for listing the item for criminal revision petition in division bench matter. In last occasion, Your Honor, I had mentioned on 23/10/2023. But that meant I had mentioned on 21/9/2023, Your Lordship, but that have not been listed. I beg to mention for listing for tomorrow, day after tomorrow, on 25/10/2023.
Revision?
That's
Revision?
Appeal.
revision not before here.
I
Appeal.
He's convicted for how much? How much?
like that.
Life.
Yes, Lord.
No, this is only for death reference cases, criminal appeal. All criminal appeals. But where will he go for revision?
No, there is- Huh? Like, Lordship, initially the matter means this matter was listed in single bench. After paging of the records, the Honorable Court has posted.
It will be listed as DB, Lordship criminal appeal, to be placed before the division bench.
Ah. Okay, let it come, let it come after tomorrow. Let us see.
Mayor, please, Lordship, I beg to mention for listing, my lord, IM, my lord. Tomorrow, IM for bail, my lord. The Costco matter, my lord, it's waiting for steps, my lord. Only will take dusty service, my lord. Can they come out tomorrow, my lord, or day after tomorrow?
Yeah, he has not taken steps.
They've taken steps, my lord, but they are not appearing, my lord. We'll take dusty service, my lord.
You have taken dusty.
We will take, my lord.
You will take, depending upon the order part.
Yes, my lord.
Okay.
They come, my lord. Tomorrow, my lord. Obliged, my lord.
May I please, Lordship, I would like to mention item number 7.
7.
Oh,
Yes.
Lordship may be given some time to file rejoinder affidavit.
Madam, what is this all the time? Rejoinder. Okay, right. What is your name?
Dear Basmatari, on
Yes,
behalf
dear.
of P.K. Chaudhary.
This D.R. Basumatari appearing on behalf of Mr. P.K. Roy Chaudhary. Praise for 2 weeks time to file rejoinder affidavit. Pusta. Last chance is given to the petitioners to file their rejoinder affidavit. Pusta. No further time shall be granted. And the matter will be decided on the basis of the materials on record on the next date. List the matter on.
After the question, Lordship.
List the matter on 14/11.
May it pleases before your Lordship. Lordship, I beg to mention item number 8 of the daily list, Lordship.
Yes,
That the matter may come after puja vacation, Lordship.
here for whom?
Lordship, I'm appearing for Mr. M on behalf of Mr. M.K. Das, Lordship. My name is not shown in the
So-
cause list.
Yes, item 8. Have you got the paper book? Have you
Yes,
got the
yes,
paper book?
yes, Lordship.
Yes, you've got the paper
Lordship,
book.
probably we have. My lord.
Okay. Right, Miss, what is your name?
MS B Chetri appearing on behalf of Mr. NK Das.
MS B Chetri appearing on behalf of Mr. MP Das, learned counsel for the appellant, and Ms. B Buyan. Additional PP submit that they have received the paper book. Full stop. Accordingly, leave this matter for hearing in usual court.
Obliged lordship.
This is a jail appeal, Lordship, and PT. Appellant was convicted under section 302 for imprisonment.
Okay, I heard Mr. B Haldar. Am I clear or what?
Legal
Legal aid, B Haldar, legal aid counsel appearing for the appellant. This is an appeal against the judgment dated 29/5/2023 passed by the court of the Sessions Judge Charadio in sections bracket CHA case number 15 of 2020, by which the appellant has been convicted under section 302 IPC. Admit the appeal, call for the LCR, Ms. B Buyan, additional PP, appears for the state. This is the matter of the 4 weeks.
If there is an IA for
Then
suspension,
Ms. B Buyan is granted 4 weeks time to file affidavit, a written objection to the application under section 389.
copy already.
Copy. no,
Comma,
one more
provided,
copy,
provided,
one more copy before
provided the copy is given to her during the course of
course of the day.
Published.
given to her by Mr. B Haldar.
Paper book is ready, my.
Okay, Mr. NJ Das, that is the Michael Cure. And Ms. B Buyan, additional PP submit that they have received copies of the paper book.
Yeah.
Accordingly, leave this matter for hearing in usual course.
Public. Lordship, as per the last order of this honorable court, I have filed the affidavit, Lordship.
Your
Yes.
father?
I am for the appellant.
I am for the respondent, your lordship, that affidavit is filed. Okay.
5 and 6.
Please, your Lordship.
Paper book is ready.
Lordship, in this matter, paper book is received.
Haven't you got?
No, your Lordship.
Did not you will-
I have it.
We will collect from the.
Just see if there's, we have got it or not, paper book. Extra,
Lordship, there are 3 paper books in the.
3 paper book.
Yes.
Why should there be 3 paper book?
That is what they
2
have
for
not
the
collected
judges
there.
and 1 for the parties, Lordship. 2 for, there should be, ought to be 1. more
And
copy.
there is one more party. There is one more.
But
appeal.
there
are
is
two
only
appeals.
3 copies in the record. It ought to have been 4 copies.
Who is there? You are for?
I'm for item number 5.
He is for item number 5.
Lalit
I am for
Chetia.
item number 6. Lordship. They are out of the same judgment, analogous.
And
matter.
this is a single paper book for
Ah,
both the matters.
So that'll suffice. Have you got the paper book? You have not, you have not got. Okay, right. Mr.
You should.
You Chowdhury, in criminal appeal number 128 stack 2022. And Mr. A count in criminal appeal 127 stack 2022. Submit that they have not received copies of the paper. Full stop. On the other hand, Ms. S. Jahan, additional PP submits that she has received copies of the paper. Full stop. Registry to supply copies of the paper book to Mr. A count and Mr. U Chowdhury. Full stop. This is the matter for hearing individual.
Lordship, and- regarding the service, Lordship,
Acha, this is what, POCSO.
we have already sent the notice, Lordship, as per the office note dated 28/7/2023. But
I mean, the note, the copy of the appeal to the OC, he has sent his staff to serve it on Gita Kakoti today morning.
Who's Gita Karpati?
Respond number 2. Because notices were issued, in fact, the report is that it is awaited. Even registries have sent the notice. Lordship will see the office note,
Okay,
but I have again sent it to the OC. Today he is served it. So
so when will the report come?
day after Thursday, Lordship will fix it up.
Okay, right. On the prayer of Ms. L. Jahan, who submits that the report of the OC regarding service of notice on the respondent number 2 will be received by Thursday.
Thursday.
Leave the matter on 19th.
Lordship. Yeah.
May I please? As part of this, detailed event service report upon the phone number 2 is not yet started. Earlier, we
How does it matter? 302 matter. 302.
Yeah.
Doesn't matter. Is the paper book required? Paper book is required. Has the records come? Records have come, no? Records have come. Right. In view of the records having been received by the registry to prepare the paper book
there is a order.
There is an order,
already.
order, is it? There is order.
Oh, yes, already here. Okay, right. This matter pertains to section 302 IPC. Full stop. And the notice was issued to the respondent number 2. To the OC Vasai Gown PS. There is no report from the OC. Why don't you get a report? You're the additional PP.
No, Lordship, I'm appearing on behalf of, I'll inquire.
You're appearing on behalf of whom?
RKD Chaudhary,
Huh?
Lordship. On RKD Chaudhary, Lordship.
Then you get the OC. First up, list the matter. After preparation of paper.
Obliged.
We have filed our objection perhaps, sir.
Yes, yes, fine.
Perhaps Ms. Bhuya.
Yes, madam.
Lordship, my senior is currently on legs, so.
Huh?
My senior is on legs right now. if
So
the
we'll
matter
wait for
will
him.
take it up some time.
But then let him hurry.
Oh, sorry.
Still in like.
What is this matter about? Give us the main copy also.
No? Oh,
But you can take it after some time, you'll not.
We're taking it up. He let him come in the meantime. Yes, madam, what is it?
no, actually, I don't have my objection copy.
Should have.
I don't know, I don't. No objection. Now here what happened is. There was an altercation between the applicant and the deceased over some financial matters initially. And then deceased used to work in the shop of the applicant. Oh, it's open. There are two eyewitnesses, it seems. In fact, PW 3 and 8.
When was he arrested?
He in fact absconded.
Yes,
It's
that's why. When
after
was he
3-1.
arrested?
He was arrested again.
Yes, just see the record.
Yes, yes, I have it with me. He was again, he absconded himself after 313.
After 313.
After
No, before-
313 also.
Acha.
Uh,
Let us see. After the incident, he absconded.
After the incident also and after 313 also.
So when was the, surely, look at the arrest memo, when was the arrest?
Acha, acha.
Since 8/3, on 8/3/21. During trial, he has failed to appear, permit my lord. During trial, he failed to appear on some of the dates, my lord. Then my
No,
lord,
just a minute.
8/3/21, he was arrested.
Huh,
And since
he
then,
was-
he is in custody.
8/3/21.
Yes, my lord, that is at page 21 of the judgment. my lord.
No, initial arrest was on 23/6/2009.
23/6, that is the next day.
Next day he was arrested.
Ah.
And then I think he absconded. No?
My lord, page 21 is lot, my lord, judgment, my lord. Appeal memo. Paragraph 5, my lord. On 8/3/21, the accused was arrested on the strength of.
Where, of the appeal memo,
Yes,
page 20.
1. Paragraph 5, my lord. On 8/3/21, the accused was arrested on the strength of NPW and produced before the court and remanded to judicial custody. And since then, he has been in judicial custody.
Even during trial, he absconded. 2014 also he absconded.
Yes,
My lord, in this case, my lord, what happened altogether, my lord, 14 witnesses were examined, my lord. Out of them, my lord, main witnesses are PW 3, 4, 5, and 8, my lord. Out of this, PW 3 and 4 and 5 claim to be eyewitnesses, my lord.
3 and 8 are eyewitnesses
3 and
to the incident.
Yes, my lord, and these,
4 has seen him running away.
yes, my lord.
Then-
Then, but my lord, main thing is that, my lord, 7 defense witnesses were examined. They all says that, my lord, at that point of time, the appellant was with them catching fish in a river, my lord. And when at around 12 in the night, when they came back, they came to know that the deceased was died in a road accident. But the evidence of all the DW were discarded only on the ground that, my lord, at first point of time when this appellant was examined under 313, he had not stated about anything, my lord.
And he has not stated anything
About that he was present along with this DW.
Friend.
While
in 313 has not stated.
first point, then my lord, some of the witnesses were re-examined, my lord. Then after, when 313 was again he examined, he stated all the things, my lord. So the court come to a finding that this is a afterthought story. That's why the court has discarded all the evidence of the defense witnesses. But whereas, my lord, PW 11, who is also a co-villager, my lord, he has also stated about that they were catching fish. And, my lord, the deceased died due to road accident, my lord. And, my lord, the medical officer, the doctor who has conducted the postmortem examination, my lord, a suggestion was put in his cross-examination that whether this can be the injuries, because there is one single injury, my lord, one in the neck, one in the this finger, my lord. So whether that injury can be caused by a road accident, it says that, my lord, if it may be caused by a road accident also, my lord.
Only sharp subjects, reports are found.
What does the medical report say?
My lord, the medical officer is, my lord, PW 12, my lord. PW 12.
Then there are 2 injuries,
Yes.
one in the neck,
My lord, if
12 inches into
My lord,
5
if lots may come
inches.
to page 23 of the appeal memo, my lord, that is the relevant portion of the judgment. Page 23, my lord.
Look at his evidence, opinion regarding that.
Yes, my lord. My lord, evidence, my lord.
No, yes, at page 23.
Yes, my lord, in the
Look at,
Okay.
it says opinion regarding death.
Yes, my lord. Death was due to shock and hemorrhage resulting from injuries as described. All the injuries were antemortem caused by a sharp cutting weapon and homicidal in nature. Time since death was 12 to 24 hours. PW 12 has examined the postmortem examination report of the deceased as exhibit 2. Paragraph 12, my lord. In his cross-examination, PW 12 has stated inter alia that such type of injury may be caused in traffic accident if it is caused by any sharp substance like glass, tin.
Any relationship between respondent, between PW3 and the deceased?
My lord, PW3 is the relative of the deceased, my lord. Tinku Gohai, my lord.
He is my relative. It only says.
Relative.
he's a relative. Accused is. a relative.
Accused is the relative, not the,
Accused is
not
a-
the deceased.
He is my relative. Accused is his relative. Accused is his relative.
Accused.
Yes.
So why should he tell a lie?
My lord,
In fact, he should be more towards your side. Blood is thicker than water, is it?
it's
Or
not-
thinner, in this case thinner.
But my lord, sometimes what type of relationship they maintain, my lord.
No, but then, you see, why should he say a lie? That's what. There's nothing, no enmity between you and the PW3.
But on the record, it is not stated anybody about.
Okay, right.
My lord,
Heard Mr.
A.K. Gupta, my lord.
A.K. Gupta, learned counsel for the applicant in the IA. Huh? Also heard Miss L. Jahan, additional PP. The applicant has prayed for suspension of the sentence made on the basis of the impugned judgment and order dated 5/9/2022, passed by the learned additional sessions judge, Dibrugarh, in sessions case number 122/2009, convicting the applicant under section 302 IPC and sentencing him to undergo rigorous imprisonment for life with a fine of rupees 10,000, in default, simple imprisonment for 6 months. The learned counsel for the applicant submit that while there were 4 eyewitnesses deposing, 4 prosecution witnesses deposing that they had eyewitnessed the incident.
Two witnesses have seen.
According to him, he said 4. Deposing that they had witnessed the incident of the applicant hitting the deceased with a dowel, 7 defense witnesses had, on the other hand, testified that the deceased was fishing, had gone fishing with them at the relevant point of time. They accordingly submit that there was no justification for the learned trial court to have accepted the testimony of the prosecution witnesses over the testimony of the defense witness. That's your case. That's all. Next part. Miss S. Jahan, additional PP, on the other hand, submits that there were 2 eyewitnesses
Really.
to the account, that is PW3 and him
Eight.
only. She
Plus, there was a motive because there was some financial.
She
issues
also
they had
submits
got.
that the impugned judgment and order shows that there was some dispute with regard to financial matters between the deceased and the applicant,
And his abscondence.
which showed that there was a motive for the applicant to have killed the deceased. Further, the applicant had not only absconded after committing the crime, but had also absconded during trial.
Ah.
She does submit that the applicant's action having clearly proved the fact that he had committed the crime, the application under section 389 CRPC should be rejected. Next paragraph. We have heard the learned counsels for the party. The evidence of PW3, who is a relative of the accused, of the applicant, is to the effect that he saw the applicant hitting the deceased with a dao. PW4 states that he saw the applicant running away.
Yes. He saw him standing and giving him threatening others.
Subsequent to threatening other persons with a dao in his hand,
Ha,
with a dao in his hand. Where do you read that?
so
Threatening
I'm
others?
speaking of PW5.
No,
Lordship
no, no.
perhaps, oh,
PW4 does
Being-
threaten.
PW4.
Threatening is
Just
not-
running.
no, threatening is not-
He also saw a down.
yeah, that is not threatening, that is- What have I said? Running away with a dao in his hand. Cut that next. Full stop. PW5 takes in this evidence that he saw the applicant holding a dao. And he also saw the deceased lying on the road with a cut injury on his neck. Further, the applicant threatened that he would kill other persons also. The evidence of PW8 is that
W5 triple. W5 triple. Thank you, triple.
PW5. No, no, also PW5 says that others are also threatened.
The accused triple that in other people.
Yes, yes. Whatever, the evidence of PW8 is to the effect that he was an eyewitness to the applicant assaulting the deceased with a dao, which caused severe injuries on the neck of the deceased. Further, the applicant had an altercation with the deceased over money. Next one. Though the case of the defense witnesses is to the effect that the applicant had been fishing with them in the river, in the Dihing River, Dihing, Dihing River at the relevant time. Where is the 313? Is it here? Just show the,
Yes, I'll take it out and.
what does he say the 313?
This is an assumption.
No, please read it.
Oh,
That is the answers.
Huh.
Only the answers.
Chandrakanta answers Misa Kotha.
Does he
Me-
say anywhere that he was fishing?
No, Misa Kotha, মোৰ হাতত কোনো দা নাছিল, মিছা কথা। এইটো কি মৃতহৰ মানুহে মোৰ মাৰিবলৈ খেদি আহিছিল। বাবে মই পলাই গৈছিলো, মই থানাত নিজেই হাজিৰ হৈছিলো পিছৰ দিনৰ মিছা কথা no, he did not say.
No such
Misa
explanation
Kotha-
has been given. Just read it, huh?
মই
No
ঘৰত
such explanation has been given. No such explanation has
Alibi,
been
he
given.
had taken alibi, মই ঘৰত নাছিলো।
No such explanation or alibi has been taken by the,
No, he took
App-
the,
to this fishing he took.
no, he simply
That's what-
said মই ঘৰত নাছিলো।
That's what I'm saying.
Oh.
No such explanation had been taken by the applicant that he had gone fishing with friends.
Hmm.
Next column. On,
No, it was taken. I think he explained, he given his, I think this was second 313, no?
Second.
One second, three.
why second, that's what, why second, why?
But what happened, my lord, there were three witnesses were re-examined.
Huh.
So again, after the re-examination, this appellant was again 313 was examined. At that time, he had explained the thing.
But if I said no explanation
That is that page put.
was given by the applicant in his examination under section 313. Taken on,
No, first 313 was taken on 22/5/2014.
22/5/2014. Yes,
This is
correct,
14
correct.
on it. 14. There he had taken this plea of fishing.
My lord, page 48 of the judgment. should be clear.
I know,
No,
this is,
how, how? What are the two dates of 313?
My
in
lord,
fact,
my lord, first one is 18/7/2012.
18/7 2012, that's what.
Huh,
It
18/7.
will be 18/7 2012.
Oh,
huh?
18/7/2012, yes. 18/7/2012, he did not take this plea. Thereafter, he was questioned on sentence. It okay, sir. Lordship will understand better. I'm sending this. Because again, 22/5, it seems some questions were put. There he answered this. Or there he did not say anything, Misa Kotha. It okay, he answered this, fishing of person. Second time, 21st May 22. 21st May 22, there was no answer, there was no explanation about fishing.
No, when did he explain about in,
22/5/2014. Lordship will see, hey, সিদিনা মই ঘৰত নাছিলো, মই মাছ ধৰিবলৈ গৈছিলো। এইটো কৈছো। Now, Justice Nandi can say, I've sent this 22/5/2014.
to stop. However, in this examination under section 313, taken again on 22/5/2014, comment, the applicant took the plea that he had gone fishing with friends on the, at the relevant point of time.
Additional questions, those were additional questions. One day, no, did you go so?
To stop this, further examination of the applicant taken on 22/5/2014 had been done due to additional evidence being taken.
21st/5.
When was the additional evidence taken?
13 was recorded on 18/7/12.
18/7.
Then 22/5/14.
What happened in between 18/7 and 22/5?
My lord,
14.
Yes.
the accused has filed one petition for re-cross-examination of 4 witnesses, madam. That is PW 3, 5, 6, and 8.
3, 5,
6 and 8.
recross examination.
Yes, my lord, that was allowed by order dated 28/7.
28/7.
There is something. Then, my lord, after they re-examined.
28/7, which year?
14.
Yes,
Oh, no?
It cannot be 14.
5:14.
Oh,
Second.
No, that allowed.
well, now.
No. You see, and you raise the question of recross examination.
my lord,
Unless there is a re-examination, then also. There is a question of recross examination.
my lord, they were first examined, my lord, then the accused had filed a petition that they failed to ask some questions to the witnesses. That petition was allowed
Allowed when?
on, my lord, 28/7/2021.
2021.
Yes.
Then no, I'm talking about between, why was the second examination under 313 allowed
Additional.
in
question.
2014?
My lord,
This
these
is
are-
of 21, that's
But-
different.
My lord, these are additional questions asked by court. At that time, he replied.
These are
Acha, this is
additional-
not a 313 then. Additional question just asked.
Written questions,
It's like 313 only.
so likely questions, my lord, put, but
Additional
stated.
question. Yes, it is 313.
313, just like that.
Additional question.
Just
Additional
like that,
questions.
after 2 years.
After 2 years.
So what have we said? I think at last sentence. Right? Cut off, just further. Cut off. What is the need?
3 times 313 questions.
When was it taken again?
22.
First of thereafter. The applicant was again examined under section 313 CRPC by the learned trial court on
21/5,
5,
22.
21/5,
2020.
2022. Next para. On, we have also noticed that the applicant had been absconding during the trial period and he had been arrested on the basis of non-bailable warrant of arrest issued against. Next para. On considering all the above circumstances, we do not find this case to be a fit case for suspension of sentence or for grant of bail and for grant of bail. The application is accordingly rejected. Then in the main case, you write, as LCR has arrived, the registry to prepare the paper book. This is the matter after 4 weeks.
But, only one thing, in the main appeal, my lord.
Just write one thing, any observations and findings made in the IA, made in this order shall not be considered to be the final observations or findings made at the time of hearing the appeal.
My lord, in main appeal, my lord, there is an office note dated 6/10/23 that neither AD card nor answer notice returned back of the informant. My lord, that is
Not required, 302 not required.
obvious.
Oh.
Item number 15.
Khan and Noor Islam had called him, took him from his house to enjoy the feast. After that, he was missing. Azhar Ali Khan, I have to check the records in order to find out. Otherwise, Azhar Ali Khan was absconding. I believe its case was filed. Actually, this objection was prepared by Miss A. Begum, so I don't know much. PW1 is the informant. She said that Sahar Khan and Anar Khan had called and taken her nephew. And thereafter he was missing.
Agar Khan.
No, Sahar Khan and Anar Khan.
Anar, okay. This is Azahar Khan.
This is Azahar Khan. And then she said, their houses are separated. Acha, those two boys had told her that Azhar Khan wanted the deceased. That is how his name came. And then his nephew, then her nephew went with them and thereafter he went missing.
My lord, 120B, 384, 17, 20, 38, and 14 of the
120B,
120B, 384 IPC. Then 17, 20, 38, 40,
17, 28,
20, 20,
17, 20,
38,
38,
40 UAP Act.
40 UAPN.
Now, thereafter, on further investigation, my lord, charge sheet was filed on
Supplementary.
supplementary charge sheet on 31/5/2018
Yes.
against 7 accused person,
Including respondent.
this respondent, my lord, he is accused number 4. Accused number 4.
Okay.
Now,
So now charges have been framed.
No, not with,
Charges have been framed against the other.
against the other accused person. What happened, my lord? Once the bail was been granted by the trial court, the matter was fixed for framing of supply of copies and framing of charges. Immediately after getting the bail, my lord, we challenged it before the entire proceeding before the learned writ court. And the learned writ court by order dated 6th August 2018. As far as the present petitioner is concerned, that is the respondent is concerned, entire proceeding has been stayed.
So against the other 11, it is still going on.
It is still charges have been framed and going on.
Witnesses have been examined.
On the last occasion, I was been informed that some of the witnesses has been examined, but 5-star witnesses has already expired, even the IO.
Whatever, that's a different thing.
that is a department.
Charge framed and trial is
Witness-
going on.
Trial is going on.
Trial.
Yes, where is the order passed?
My
Is
lord,
that-
before that, my lord, this accused, he is charged as accused number 4, and the section was 39 and 40 of UAP Act,
39 and 40.
40 of the year. Now, this present accused, my lord, he was working as Land Resource Department, Government of Nagaland, my lord.
Joint director.
Yeah,
Yes, madam.
He
And-
retired.
Resources Department, going on. Joint Director,
Retired.
Joint,
He's retired as on date.
Pardon, my lord?
He's retired.
My lord, he retired and now he took voluntary retirement. And now he's a sitting member of district assembly in the Nagaland government.
And he's the MLA.
He is an MLA, madam. He resigned from the services.
that is not necessarily possibly voluntary retired. That is not necessary.
He retired.
Anyway, he volunteered, he's retired.
He retired because
Retired,
otherwise
retired.
retirement.
Whether you retire, whether it is any form of retirement, it is retirement.
Retirement, madam.
No,
Anyway, so he made a lot of money, it appears. Because I believe that you need a lot of money to win elections that time.
My lord, that assumption is there because of past conduct, what happened in other parts of North.
That's what we have been hearing. We don't know if it's true.
My lord.
Hopefully, it might not be true, that it's not because of money, but because of their integrity and statesman-like conduct, maybe hopefully.
Because prima facie, you have to trust the CEC, Chief Election, Election Commission, we have to trust. Because
No, election commission, nothing wrong with election commission. They just have to count the votes, that's all.
No, no.
We're just talking about him, whether he is a very very, very far thinking statesman like,
My lord, one more accused, my lord, he also retired from the services. In this case,
and he's also MLA.
he also contested this election.
He also won.
He also won. Acha.
Good, good.
And that is a state of affairs.
I know that's a different issue.
Anyway, people has
Good for
accepted,
them, good for them.
people has accepted.
Yes.
Now, Madam, in the supplementary charge sheet, the charge was that, investigation established that accused Ellen Jamir, accused number 4, was working as Land Resources Department Kohima as Joint Director DDO and had voluntarily appeared before the CJM Dimapur and given his confessional statement before Chief Judicial Magistrate Dimapur, Nagaland on 9/5/2017, in which he confessed that a huge amount of money was given to underground.
No, okay. 164,
Before CJM,
when?
that was on 9/5/2017.
9/5/17, okay.
The hearing. On scrutiny of documents received from Land Resources Department, Kohima, it was established that accused Alenba Jamir and accused K. Lasito Sikri Kesiar, Land Resources Department, Kohima, that is his accused number 5, had paid huge amount of money to NSCNK and other various underground factions operating in Nagaland. Accused K. Accused number 5 had paid money to accused that is accused number 2 also on many occasions on behalf of NSCNK. Now, that was the allegation, Malad. Now, he applied for bail, Malad, and accused number 4, and he was granted bail. Thereafter, Malad, the appeal, that is, your lordship will find the impugned order. Impugned order is on 23/3/18. 23/3/18.
Of the division bench
Yeah,
of this court.
no, that is a trial court, my lord. That is, this is the present appeal, my lord, against the bail.
For you, it's a impugn. It's a impugn order, yes.
Impugned order,
Impugn order granting bail.
granting bail, that is on 23/3/18. Page 86 of the appeal, my lord. And this is a appeal before lordship. Now, as your lordship has already seen other matters, my lord, and may I just get this, your lordship has already taken, my lord, that SCC 2023 SC
Yes,
online
yes.
for 445. While other government servant, my lord, on being litigated by High Court, my lord, they have gone to appeal before the Supreme Court. And the ground was taken that since they are government servant, other factors reflected and waivers granted.
Because they were compelled to contribute. That's what the Supreme Court has said.
Yeah.
It is not that they voluntarily gave it. They had no choice. It was their life or gift. So that is why in similar matters, they were asked to pay. I mean, they were asked to, their bill also was restored.
The other factor, my lord, what we say that this government servant did not make any complaint or file any.
Correct. That is one lacuna. That is one thing they are supposed to complain. They're basically allowing things to be stolen, government property to be stolen.
Right.
Supposing some thief comes into your own house, then you will probably report it, probably obstruct him or
Right.
do something to ensure that it is not taken away.
Right.
And if you don't have the physical means to stop him, then you'll allow him to take away, then you'll go and make a FIR to the police. Now, in this case, nothing was done.
Nothing was done.
You have, okay, you were compelled to give, no doubt, you will give. But subsequent to that, you had a duty to go to the police and make a report that this has happened. Offence has taken.
At least that can at least establish something that you are not giving it voluntarily, but
Yes, that you are not part of it.
but
Otherwise, it is not illogical to think of the stand taken by the NIA that you were a part of it. You were involved in it. But the fact remains that at the end of the day, it is been a large scale exercise going on. Anyway, the thing is that more than that, right now, the only thing is with regard to bail. Now, they have been on bail for more than 5 years. They have not absconded. They are not going to abscond.
yeah,
And-
that is other factor.
Yes. So 5 years have gone by.
Yeah, that
And
is
in
other.
a similar case, the
Yeah.
Supreme Court has granted them bail.
Your lordship has already taken this.
Yes, so
That's
now I think this court has also passed orders. I do not know where it is.
No, no, just
Because
I,
once they have passed those
Yeah,
orders,
yeah.
we don't keep track.
Yes. 2-3 orders, your lordship.
2-3 orders I have passed. That is what, when the counsel for the respondent, he didn't, I thought he knew about it. He didn't.
No, my
On
lord.
the last date. He didn't know. Anyway, so where are those orders?
Somewhere, I just missed it, but it is not in the file, Bharat. I could have brought it, Bharat, sometime. I can,
Okay, now anyway. The thing is that it would have made my job easier, our job easier.
Bharat.
If
If
that,
it is-
you got similar orders.
My lord,
have-
my mistake, my lord. I would have brought it, but
You didn't know about it.
my lord, I know about it. And in fact, I tried to check these orders from our data. And for the last, yesterday evening, I tried to look in. The software, I believe, the High Court website, it's getting hanged. It's the data is not revealing. Order not uploaded, order is not. So I tried, even today in the morning also. That is not, because there are 7 or 8 government employees. Even one Lasito Seki is also there. I tried his order also, because he was there, Tuluna Pongan.
Anyway, I think we have passed 2-3 orders.
Yes, but Tulula Pongan, I believe it was
I've got-
here.
But I've got a hard copy, Bharat. The only thing is that, Mother, if your lordship,
I'll have it photocopy. Just give me the hard copy.
but yeah, no, that is, if I get some time, Bharat, I have to bring it about it, sometime.
Okay. So anyway, so that's it. Anything else?
But nothing more. The only thing is that we object, the bill.
Correct. Naturally, you have to object.
Yeah, we have to object for. Continue. That may be recorded, and if your lordship wants, I'll just bring it and.
Yes, it'll be better so that we have a.
But,
so
because
that
we
there's
have
no
given-
change.
The only part is that, Manoj, in other case, they were accused of something different. And their allegations were something different. And he is here, accused of 4, and his allegation is that he has made a confessional statement. That is your lordship. Take care of. That is a part.
LS confession, my lord, it is not LS confession. They are saying that it's an LS confession because I have seen the
No,
paper.
they're saying it's a confession. You're saying it's an alleged
LS.
confession.
My lord, it is not a part of the record, my lord. They have not filed
No,
it.
that is a different issue. That will take it up. But he can make his submission. What is it?
And my lord, one more from my side, I would like to make one submission, your lordship. Kindly come to the bail application, my lord. Impugn bail order.
That is- Tamara Kolo.
86, 87.
Yes.
Your lordship is there. This is the impugn bail order. Kindly come to the bail application, my lord. That is page 80, annexure G, which the NIA has brought on record. My lord is there.
Yeah.
The lordship will kindly appreciate that in NIA case RC 116, NIA Guwahati under section 384 IPC, section 25 1B of Arms Act, section 7 and 8 of NSR, section 13 of Drugs and Cosmetic Act, and section 10 and 13 of UAP Act. Your lordship will see section 10 and 13,
Give us the UAP Act.
my lord.
That is their bail petition, Mother.
No, that's why against that, in that bail petition only the order was been passed, which they had impugned. Kindly come to the section 43 D5. Uh, 43 D5.
Yes.
Your lordship, the rider of 43 D5 comes into place only with an offense with respect to an accused person, where the offenses alleged are with respect to chapter 4 and chapter 6. Now your lordship will see section 10 and 13. 10 and 13. Each with chapter 3. Each with chapter 3. So the rider of 43 D5 does not come into operate.
But then you have been charged under 39 and 40.
No, my lord. My lord, your lordship have to appreciate. Charge sheet has been filed subsequently. When the FIR was filed, registered, I got the bail order on the basis of that FIR. I was not on charge sheet at that point of time.
Okay, at that time 39, 40 was not.
Not there. So the question of their argument that 43 D5 will come into play is wrong, fundamentally wrong. And that has been held in this which judgment which my friend is also relying, which I have given your lordship. There also your lordship in Tawa Faisal's case, the Supreme Court has held the rider of 43 D5 will apply from the date of registration of the FIR. And as far as my FIR is concerned, it was of 10 and 13, not of 39 and 40. So the argument, fundamental argument that 43 D5 comes into is false flat on part. That your lordship may record it. Nothing more, nothing more, nothing more.
In a case, hypothetically, in a case, but where there is 323 and subsequently it is converted to 302, what will do?
No, but then you see, but you see, that will depend upon when the bail application is moved.
More.
It depends upon when the bail application is moved. Prior to 39 and 40, then there's no question of 39 and 40 coming into play.
Yes.
But, just one more thing.
And even your lordship will appreciate the judgment which I have put on, placed before your lordship, as far as the interpretation of section 39 and 40 is concerned. Even this, the Honorable Apex Court has held, relying upon the PUCL skill, that an intention has to be there with respect to furthering of their intention for terrorist activities. Here, it is the prosecution's case that we gave the money. How we gave the money? On the threat of extortion. So the basic ingredient of manslaughter is not there at all. And I'm not going to argue on that point also, because at that point of time, 13 and 40 was not there with me. But it was only 10 and 30, 10 and 13.
Just one more correction, Babu. The bail impugned order is dated 23/3/18.
Impugned order is the 23/18. Yes.
18. Now,
Charge
supplementary
sheet supplementary on
31/5/18.
5/18.
After.
But when was the bail allowed? When was the bail allowed? That is the issue. Bail order allowed when?
Bail was allowed on 23/3/2018.
Same day.
No, 23rd March 2018.
Correct, same day as your application.
Yes, my lord.
So no notice issued also.
No. It was a notice was issued. Notice was issued.
No, how can, huh?
Your lordship, kindly see the order, your lordship. Learned PP Satyanarayan present for the NIA. Learned Advocate S. Borgman is present for the accused.
So
Today-
Today is 6 for hearing.
Yes,
Of bail number 1158.
yes.
No, but.
My bail application was filed on 9, was filed on 10. NIA has received on 19/3. Your lordship will kindly see page 80.
Yes, anyway.
Your lordship is there?
93, just 4 days.
4 days. And my,
So you don't find it surprising?
my lord, the notice of 43.
19/3. I wish I had 19/3. 2018
18.
is what date? Monday, Tuesday, what day? Let's see from your phone. Have you got calendar on your phone?
Yeah, 93.
19/3/2018. I just want to know the date.
My lord. And my lord, your lordship will appreciate one aspect also. The notice as mandated by 43 D5, as mandated by my 43 D5, will have got two operating stands. One, a person who is accused of an offense under chapter 4 and 6 won't be granted bail, won't be considered. First, the PP must be given an opportunity. And the perusal of the case diary or the charge sheet, prima facie true. Now here,
Monday.
here, we have given them the copy, we have served it. Even though 43 does not come into play, we have done it as per a regular bail proceeding. Now, the London Trial Court has passed the order on the basis of allegation made on 10 and 13. 10 and 13. So the question of 43D5 does not come at all because statutes.
Correct.
My lord.
Why,
And
why didn't you take this plea earlier, before the division bench?
my lord.
Why didn't you take this?
Oh, no. I at that time, what happened in this matter,
Ah.
since my learned senior colleague is also there, when the first order was being passed, order was being passed, batches of orders were passed on the accused person. That this particular case happens to be the first case of NI in Nagaland.
Oh, yeah.
So what happened? The batches of cases were in file. So this person came to me through a lawyer counsel, and when we saw the order, at first when we see the order, there's no sections and nothing was there. And I was saying that prima facie, because couple of months back, I had argued the full bench matter, where the rider of 43D5 was been explained. So I said, no, on the face of it, it does not look good. You have to surrender, because PP was also not heard. So we considered the fact.
But it is heard, present.
Pardon, my lord?
Out here it says present, learned so present for an IA. First line it says.
No. This is the subsequent order, man.
Okay.
This is the subsequent.
Okay.
First, what happened, your lordship? When the NI arrested those persons, someone filed application for medical grounds. The trial court randomly passed the orders, even a magistrate court. Against those orders, the NI came before the High Court, this court, challenging that the riders of 43D5 has been given a toss by the trial court in Dimapur. And lordship, this honorable court took cognizance and set aside those orders and remanded back.
And those cases were under 3940?
No, 10-13, with respect to this. The government servants, your lordship. Because with respect to the underground fraction, they were already arrested. Now this government servants. So again, they approached this court, the London Trial Court passed very reasonable order. I believe, your lordship, one order was passed by Justice Sukadaso, of former justice. And that order has been upheld by the Supreme Court, setting aside the order of the division bench. This order, which your lordship I am referring, it is an order passed by the trial court, Justice Sukadaso, my lord, and which is upheld by the appeals court and negating this division bench order. But these are the peculiar facts.
Anyway, only thing is that if, can you give me the order in the afternoon?
Yes.
I can give it to my chamber.
Half an hour to 1 hour.
No. Okay, right. Heard, Mr. Dikeda, Learned Senior
Dikeda.
Counsel.
Take it up.
Learned Senior Counsel appearing for the NIA,
And I.
assisted by Miss
PK Darji.
PK.
Darji.
Also heard Mr. S. Borgaheim, Learned Counsel for the respondent. In this appeal, the order dated 23/3/2018 passed by the learned special judge, NI, Nagaland, Dimapur, in connection with RC 1 so and so granting bail. In this, the order dated 30/03/2020. The second paragraph. The second paragraph. Okay. Full stop. Next paragraph. Mr. Das submits that charge sheet has been filed against 3 persons on 25/1/2017 under section 120B /34, 384 IPC. And under section 17/20/38/40 UNAP Act. UAP Act. Thereafter, a supplementary charge sheet was filed on 31/5/2018, whereby and against 7 other accused persons, including the respondent, wherein the respondent has been numbered as respondent number 4 and charged under section 39/40 of the UAP Act. 1967. Next paragraph. The learned senior counsel for the applicant further submits that trial is going on before the learned trial court with regard to the charge sheet and supplementary charge sheet filed by the NI. He submits that the respondent, who was the joint director,
Supplementary charge is not there, my lord, here.
who was the joint director
Land Resource Department.
of the Land Resource Department of a government of Nagaland, has taken voluntary retirement. Voluntary retirement, that's all.
No, that's all.
What-
But he made
Huh?
a confusion, but that's
Full
good.
stop. He also submits that the respondent has given his confessional statement under section 164 CRPC before the learned CJM Dimapur on 9/5/2007. He accordingly submits that he accordingly pleads that the bail granted to the applicant should be set aside as the same had been granted in violation of section 43D(5) of the UAP Act, 1967. That's all? No. Anything else? No.
Rest, my lord, the other thing will come, my lord.
Mr. S. Borgai, learned counsel for the respondent. On the other hand, submits that at the time of filing of the bail application and grant of the bail application by the impugned order dated 23/3/2018. The applicant had been charged only under section 10
10 and 13.
and 13 of the UAP Act. Besides other sections. Besides sections of law, besides sections in respect of other criminal acts. As section 10 and 13 of the UAP Act is not included under chapter 4 and 6 of the UAP Act, section 43D(5) of the UAP Act was not applicable. At the time, was not applicable to the applicant's case. As such, there was no infirmity with the decision of the learned trial court in granting bail to the applicant. He also submits that the the issue of. He also submits that the Supreme Court in the case of. So. The 2023 6 SCC 58. Had. Distinguished, had dealt. In a similar matter. As the present case. And. Had. Distinguished cases of persons. Who had who had indulged in extortion. For furthering. The activities of the organization. Against. The government of India. Come on, while on the other hand. Holding them. They were another class of persons. Who were government servants. Who had been compelled. To contribute. Money to the government. And could not have been. Placed in the same category. Of the extortionists. That's all.
My lord, to the money to the government, money to the underground section.
Whatever I said. Okay, the underground practice. Anything else?
My lord, that's all.
Yeah, he accordingly submits that the bail granted to the applicant by the impugned order dated 23/3/2018 should not be interfered. We have heard the learned counsels for the party. The facts of the case show that the petitioner, that the applicant, that the respondent had been charged under section 384 IPC, section 25(1)(b, Arms Act, section 7 and 8 of the Nagaland Security Regulations, NSR, section 13 of the Drugs and Cosmetics Act, and section 10 and 13 of the UAP Act. This is at page 80. Yes, Luca. The petitioner, the respondent submitted his bail application on 19/3/2018 before the special judge NIA of Nagaland. The learned special judge NIA Nagaland thereafter. Wait, before that, before submitting bail application, submitted bail application in connection with SBN PS case number 90/2016. 90. Correct?
No, my lord, it is the bail application will be filed in NIA RC 1/6.
No, but a PS case, what is the PS case number?
No, my lord, it was since it was NIA has taken over the investigation.
Okay.
It will be-
In connection with
NIA
NIA R /C/01/2016/NIA-GUW. Next up. The special judge NIA Dimapur, Nagaland Dimapur. Thereafter, passed the impugned order dated 23/3/2018 in RC 1/16/NIA-GUW, granting bail to the applicant who at that time was serving as joint director
my lord,
in the
Land Resource Department.
Land Resource Department, Government of Nagaland. Where is the division bench order?
No, division bench did not pass any order,
Not in this case.
not in this case. And your lordship will kindly see for my lords at page 84, page 84 of the bail application matter. Page 84, my lord is there.
Yes.
kindly come to serial number 8.
Yes.
That is reflected in the forwarding memo of the accused petitioner. It prima facie shows the accused was arrested under section 10 and 13 of the UAP Act. Hence, if we peruse the 43D5, it will reveal that the riders provided the said provision shall not apply in the present case. Specific contention was there. Accordingly,
That is a contention matter.
on the basis of the FIR and the arrest note.
Anyway, let us, please,
Because
we have heard this enough. Madam. Next, right. The issue with regard to the grant of bail. In NIA cases in Nagaland wherein government officers had apparently given government money in various departments to the underground factions had been a subject matter of this court and the Supreme. Where is that division bench judgment? That is Ajit Singh's judgment, I think.
Which one, my lord?
That is Ajit Singh's judgment, no, the division bench, where all those bails were cancelled. Unfortunately, I don't have. Where are those? That is Ujjal bail, there's no. Full stop.
Or she will find.
Full stop. Besides, no, keeping that aside, comma, with regard to the present case also, it is seen that, no, cut that, full stop. But you went against this order before this division bench.
Pardon, my lord?
It has gone, right. Subsequent to the above, comma. The NIA filed an appeal before this court by criminal appeal number 435/2017. Correct? No, yeah, come to page 74.
No, my lord, this was the order, earlier order, which they have challenged in the High Court, and the High Court has remanded back, directing me to surrender.
Ah.
And the order which, impugn order which your lordship is referring, which is present concern, that is of 23/3/2018.
No, Mr. Counsel, yeah, you see, what has happened is this 74, page 74,
My lord,
this is against the impugned order. Isn't it?
no, your lordship,
This is different.
it's different. This is totally different.
This is a different case.
It is totally different order.
He's got a different case again. He's
No,
got a
no,
different
your
case.
lordship, let me explain. When NIA arrested me, I was granted bail by the learned court below.
Ah.
Against that order, they came before this court
Yes.
saying that the learned trial court erred in granting bail.
Correct.
The honorable division bench said that looking at prima facie, looking at the 43D5 aspect, let it go back and proceed as per law.
Ah.
Accordingly, I surrendered before the court. I appeared and I filed my bail application, which your lordship has produced. And the honorable court passed the order of 23/3/2018, which has been impugned in this patent proceeding.
Okay. So this is different. It is prior to 23/3.
Yes, madam. So this may,
Yeah.
he came,
Is it 90?
yes.
So that 23/3 is still pending here.
23/3/2018 is the subject matter.
That much I know.
In other way, my lord, this appeal is with connected to 23.
Okay, then what have I written that the one you have just cut, keep it up. No, cut that. No, the one prior to that. And Supreme Court in various uh, in person to the various bail orders given by in person to the various bail orders given by the learned special court in Nagaland. For a little background into the issue, we would have to go into, please give me the earlier orders, that will help. Otherwise, I will have to refer those.
But I'll do that.
As to how this order has come up, the Supreme Court, the order.
Yes, my lord. My lord, your lordship will find that order. This order were passed.
But can it be taken off sometime? It will be easier.
My lord, series of matters were there. 416 of 2017.
No, you just give me those orders that I had passed. Those orders that I had passed.
Yes, my lord.
I think 2-3 orders are there. Just give me that.
Turla Pongan might your lordship had filed.
I don't know, I have passed
Take
2-3 orders.
Yes.
from my time.
Take it off
Already.
sometime.
All granted bail. orders.
All granted.
So I just wanted to know that.
Okay.
We'll take it up at what?
My lord.
2. What, the 12 o'clock? 10 to 1.
It's getting to 30. One. Maybe one your lordship will be writing.
10 to 1.
Two.
10 to 1, we'll take it up.
Let us see, my lord. Let us see.
So we can dispose of this other one. Let us-
I
I'm
found out
sorry,
that
my lord.
date of
The
arrest-
first call, I was not present, my lord. My lord, after going through the impugned judgment and the evidence,
Yeah,
well, I don't find any direct evidence against this accused appellant, my lord. My lord, if your lordship looks into the FIR first, I have been arraigned as an accused. Your lordship would kindly look at the FIR at page 107 of my memo of appeal.
you know the main field.
Yeah, it was late in here. Body was found behind his house and there.
My lord, your lordship will look at page 109, the typed copy of the FIR. This is how the investigation initially started. my lord.
Yeah,
With due respect, it is stated that the below mentioned accused person with prior conspiracy, my nephew Noor Alam, the deceased, my lord, son of so and so, second part, called out from my home on the evening from my house by accused number 1, 2, and 3 to enjoy the feast of Eid. Since then, my nephew unable to trace. Now, 1, 2, 3, and is not the present accused appellant before your lordship to enjoy the feast of Eid. Since then, my nephew unable to trace out, we are charging our nephew in various places and also visited various times the house of the accused number 1, 2, and 3 for searching. And the other accused inform us that they were unable to trace out the accused number 1, 2, and 3, and they are not aware where they are. During this, lastly on 1/8/2015 in the evening, we received an information about Farooq, son of Sirajul Haq, that a fisherman saw a dead body at the bill of eastern side of Kakopani market, and immediately we rushed to the place that the dead body is our nephew's. Their injury marks and the neck appeared to be in a slit state. It is hereby mentioned that in this murder, the accused number 1, 2, and 3, as well as the other accused person whose names are mentioned in this FIR are directly involved in this case. But in order to charge our nephew and to perform his last rites, there was a delay in filing this FIR. Therefore, now your lordship will see 1, 2, 3 are different. I am at serial number 6, Azhar Khan. Now your lordship will see this, how the dead body, in regard to the dead body, because one of the witnesses said that the dead body was recovered behind the house of the accused appellant. Now you are in regard to the recovery of the dead body, my lord. I have compiled a chart, my lord. Let me take your lordship to the chart, and it will be easier for. In the memo, body of the memo, appeal only I have. At page 12, my lord. Page 12, I have given the list of the witness. Sorry. At page 18, my lord. Page 18 of the memo of appeal. I'll take to those statements, but I have summarized in regard to the recovery of the place, because this whole case is based on circumstantial evidence. And the person who first took out the deceased from the house, my lord, they have been acquitted. And you also will see. Now in ground number 11, I have given, my lord, for that the different prosecution witnesses have stated differently as regard where the dead body was found. Now you also will find, so at the first PW7 said it was found in a bill where he had gone fishing. PW1, PW2, PW3 said that it was found in a pond situated at the backside of the appellant. Then as per PW4, the informant, he was told by Farooq, PW7, that one dead body was found on the southern part of the house of the appellant, where he went with others and identified the body. The next witness, PW5, said was found floating in a stream. PW6 said that it was found in a paddy field. PW10, my lord, fisherman told that the dead body was floating in a nala of the Brahmaputra. Then PW11, my lord, he said that the dead body was floating in a river tributary and near the dead body. Now PW12, all these witnesses which I have compiled in ground number 11, their places of recovery of the dead body is different. That is one aspect where, because ultimately when the body was found near my house was burned down. Now you'll also see what are the evidence against this person on the basis of which I have been convicted under section 302. You'll also kindly see the evidence of PW1 at page 130. Nobody has seen Malak me directly involved in the murder of the deceased Malak.
Yes.
Now, if your lordship looks at page 130, the first few lines your lordship can omit. That on the date of the occurrence of the incident, the deceased was present and walking in my house. While the deceased was walking in my house on that time, then one Sahar Khan and Anar Khan came to my house and called my nephew. These two boys told my nephew that accused Azhar Khan and Nazar Khan wanted him. So the first link is Shahar Khan and Anar Khan, and both of them have been acquitted. Those two boys told my nephew that accused Azhar Khan and Nazar Khan wanted him. Accordingly, my nephew went to those two boys. I thought that my nephew went with his own house, but the guardian of my nephew told me that he did not return back to the house. Thereafter, we started searching for the deceased. We started searching for the deceased throughout the whole night, but could not find him. Then on the next day evening, the dead body of the nephew was found in a pond situated on the backside of the accused Azhar Khan. And that's why villagers burned the house of Azhar Khan. Now, there is nothing more in this examination in chief. Cross-examination is in detail at page 32, 132. And the only relevant.
What about in page 131?
Yes, ma'am.
You have not read this portion of their recovery.
Hello?
After the fourth line, after some time,
On the day of the page
31.
yes, I'll read it. No problem. We saw a deep cut injury on the neck of the deceased. I also saw a rope was tied on the neck of the deceased. The parents of the deceased came to that place. Many people gathered there. After some time, police also arrived at that place. Police recovered one axe, one rope, one bloodstained knife, bloodstained cloth from the house of the accused Azhar Khan. But these were never exhibited in the court. But you also will see the London Session Judge has also observed that these vital materials have not even been seized. How can they connect me with the material which they have not seized also, madam? I'll take your lordship directly to the observation of the London Session Judge in the impugned judgment, madam. Just a moment. That paragraph what কৈছে? Just a moment. So, Madam, the learned session judge has observed in one paragraph about this seizure, madam. Or I can take your lordship to the impugned judgment last page, the material object which were seized, madam. That your lordship will find at page 86. The other judgment. Twenty witness and one court witness, मतलब I will just एक पैराग्राफ में है, देखो जो सेशन जज बोला है कि पुलिस ने चीज नहीं Well, you'll also find that at page 70. The session judge has referred in the impugned judgment. I'm sorry, I took some time now. Page 70. Paragraph 68. As far as the recovery is concerned, it can be seen that many witnesses, including PW1, PW2, PW3, and PW4, mentioned that bloodstained shirts, axe, and dagger were recovered at the house of accused number 1. But interestingly, police has not shown those articles in the seizure list. Whether those were deliberately not seized by the police or there were no charge article found at the register is shrouded with mystery. Now you'll also again go to PW1, madam. I'll come to the medical report also. You'll also again go to page 130. So police recovered one axe, one rope, one bloodstained knife, bloodstained coat from the house of the accused. And there is no FSL report to sustain also that this belonged to the deceased madam. The FSL report and scientific report are there. I will take your lordship to be there. So this were neither except the madam, the rope was seized, but if your lordship looks at the impugned judgment, the rope was seized. But that rope was the rope used in the, where is again shrouded in mystery, madam. Rope and stick and dry grass was seized. Dry grass, madam, when the FSL report came, it says that human blood AB, but whether that is the blood of the deceased is or not, that is the missing link again, madam. If your lordship looks at page 88, your lordship will find that rope and stick and dry grass were seized. One rope which they are talking about. Now your lordship will see detailed cross-examination was done at page 132. First day it was reserved, manner later on it was done, manner. The distance between my house and the house of the accused Nazar Khan is about half kilometer away. The Kalapani Bazaar is situated at a distance of 1 kilometer away from my house. There are 6 inmates in my house. Salam and Razak are my next door neighbors. I did not accompany deceased Nur Alam to the house of the accused person. I did not go to the house of the accused Azhar Khan. Accused Azhar Khan and Nazar Khan did not come to my house. She has specifically said that this present accused appellant did not come to a house. Sahar Khan and Azhar Khan came to my house at 10 a.m. Matlab Ali is the father of the deceased Nur Alam and their house is situated at the distance of 1 kilometer away from my house. I went to the house of Matlab Ali after discovery of the dead body of the deceased. I did not know the time when the guardian of the deceased told my husband regarding missing of his son. I did not see the dead body of the deceased when it was recovered. I saw the deceased at a later stage. One Farooq saw the dead body of the deceased for the first time when he went to fishing. I did not go to the house of the accused person after recovery of the dead body of the deceased. I was not present when the dead body was brought to the market. I did not go with Husanara and Pinjara up to the police. Accused Nazar Khan used to come to our house sometimes. There was no previous dispute between us and the accused person. The dead body was found near a pond. Police arrived after discovery of the dead body. I did not state before police that guardian of the accused Noor Alam told my husband of a phone that his son did not come back to his house. I did not state before investigating authority that police recovered one axe, one rope, one blood sack. Your Lordship, can you take note of this? I did not state before investigating authority that police recovered one axe, one rope, one bloodstained knife, etc., and one bloodstained cloth from the house of the Azhar Khan. I did not see the occurrence of the incident of murder. I did not see as to who had killed the deceased Noor Alam. It is not a fact that Sahar Khan and Anar Khan did not go to my house to call Noor Alam. It is not a fact my nephew Noor Alam deceased did not go along with Sahar Khan and Anar Khan on the date of the occurrence of the incident. It is not a fact that my nephew Noor Alam did not go to the house of the accused Azhar Khan and Anar Khan. It is not a fact that we made a false case against the accused person at the instigation of police due to the enmity with the accused person. After discovery of the dead body of the deceased, the house of Azhar Khan and Nazar Khan burned into ashes. It is not a fact that we, along with other village people, made a conspiracy. Now your Lordship will see PW2. Complainant is my own maternal uncle. I know all the accused person. This is victim is my cousin brother, who is the son of my own elder maternal uncle. Incident occurred in the year of 2014. On the next day of the Eid festival, I went to the house of the maternal uncle Noor Hussain. On that day, my cousin brother Noor Alam was also present there. On that particular day of the incident, one Sahar Khan and Shahjamal came to the house of my maternal uncle and called my cousin brother Noor Alam deceased. Initially, my cousin brother refused to go with her. After some time, they again came back and in the evening and called my cousin brother Noor Alam. In the evening, my cousin brother Noor Alam went along with Shah Khan and Shahjamal. I and my cousin Pinjara also went along with them. This is your Lordship say. I and my cousin Pinjara also went along with them. After going little late, when we reached a particular river bridge, these two boys named Shah Khan and Shahjamal asked me and Pinjara to return back. Accordingly, we came back to the house of our maternal uncle. However, my cousin brother did not return back home on that night. On the next day evening, the dead body of Noor Alam was found on a pond situated on the backside of the house of the accused Azhar Khan. They said that the dead body was recovered on the backside of the house of the accused Azhar Khan. I also went to see the dead body of my cousin brother. Our relatives and guardians of the deceased also went to the place. That many people of our village went to see that the body. Police was informed who arrived at that place. Police recovered bloodstained stick, bloodstained knife, and bloodstained cloth from the house of the accused Azhar Khan. I saw the dead body of the deceased. There was a deep cut injury on the neck of this deceased. There was profuse bleeding oozing out of the nail plate recorded by state. Now, cross-examination of PW2 is at page 136. Kakaponi market is situated at a distance of about 10 minutes walk from my house. The house of the complainant is situated at a distance of 2 minutes walk from my house. The house of my cousin Noor Alam is situated at a distance of 20 minutes walk from my house. I did not go up to the house of the accused Azhar Ali Khan by accompanying Noor Alam. I did not go up to the house of the accused Azhar Ali Khan by accompanying Noor Alam. Pinjara also did not go up to the house of Azhar Ali Khan. I did not see the dead body before recovery. Pinjara also did not see the dead body before recovery. The dead body was taken to Kakapani market and there were more than 1,000 people gathered to see the dead body. The dead body was little decomposed. I did not see the incident of assault on the deceased. The accused person came to the house of the complainant, Noor Hussain, early in the morning of 6 a.m. On that day, I went to the house of my maternal uncle on the date of the incident in the morning. It was Wednesday. The bridge near Kakapani is situated at a distance of 5 minutes walk from the house of the complainant. The dead body was seen by one Alamgir, son of Chiraz. I did not know what was inside the pocket of the deceased. The dead body was found on the western side. Now here you can hear the dead body was found on the western side of the house of Shiraz. I know Farooq. When I went to the house of the accused Azhar Ali Khan, I found that 100 people were there. It is not a fact I did not go to the accused Azhar Ali Khan. It is not a fact that police seized bloodstained stick, bloodstained knife, and bloodstained cloth at the house of the accused Azhar Ali Khan. It is not a fact that I did not state before police that I saw recovery of bloodstained stick, bloodstained knife, and bloodstained cloth from the house of the accused Azhar Khan. It is not a fact that I did not tell before police that I saw a deep cut injury on the neck of the deceased. It is not a fact that I did not state before police there was profuse bleeding oozing out from the neck of the deceased. It is not a fact that the dead body could not be identified. It is not a fact that first, your lordship, you have said that the dead body was decomposed. In a decomposed body, he says that I did not state before police there was profuse bleeding oozing out from the neck of the deceased.
But he said before the police that the recovery of the axe and dagger and everything.
Well, these are they have said, but there is no recovery from the police. If they have been recovered by the police, then there will be a seizure list. And if there was a seizure list, then they would have sent those items for forensic examination. Those are missing links, my lord. They may have said it in their evidence that they were recovered by the police. Because simply even recovering a dhow with blood, whether that is human blood or not, whether that is a blood of the deceased or not, those things will come up because this whole case is based on circumstantial evidence. Any missing link will, the benefit will go to the accused, my lord. It is not a fact that the accused person did not go to the house of the complainant on the date of the occurrence of the incident. It is not a fact that the deceased went missing prior to the occurrence of the incident. It is not a fact that since I am the cousin of the deceased, therefore I have been made a false witness. It is not a fact that I tendered false evidence, and these are the all suggestion. Then your lordship will see PW3. They are all relatives, my lord. Complainant is my maternal uncle. I know all the accused person. This is Nur Alam, is the son of my paternal uncle. The incident occurred in 2014. Eid festival, my cousin brother Nur Alam was walking in the house of the complainant, who is my uncle. On the date of the occurrence incident, one Sahar Khan and Anar Khan. Sahar Khan and Anar Khan's name, everybody has said who took the deceased from the house, my lord. Call my cousin brother Nur Alam deceased to somewhere else. I and my cousin sister Husna Parveen followed my cousin brother Nur Alam. When we reached the river bridge, Sahar Khan told us to return back, and they went somewhere else, taking my cousin brother Nur Alam. On the next evening, the dead body of my cousin brother Nur Alam was found in a pond situated on the backside of the accused Azhar Khan. The dead body was brought from the pond. At the time I was not present. I went to see the dead body. After some time, I saw a deep cut injury on the neck of the deceased. On the next day, police visited my house and also visited the house of the accused Azhar Khan. I also accompanied police to the house of the accused Azhar Khan. My cousin sister Husna Parveen also went to the house of accused Azhar Khan. We saw blood stain in the house of the accused Azhar Khan. Police recovered bloodshed wooden part of axe, rope, and bloodstained cloth. All these relatives have said in the court that they have recovered. But where are those items, my lord? Police seized all those articles. Again, it just says police seized all those articles. Police recorded my statement. I deposed the same story before police. We suspect that since the dead body of the deceased was recovered from the backside of accused Azhar Khan, and since the several bloodstained materials were recovered from the house, of therefore accused Azhar Khan is behind the murder of my cousin brother Nur Alam. My father's house is cross, my lord, at page 140. My father's house is situated at a different village from the house of the complainant. I did not see the occurrence of the incident. I went to the house of the accused Azhar Ali Khan on the date of the occurrence of the incident. But I did not state before police that I went to the accused house Azhar Ali Khan along with police. I did not state before police that Husna was accompanied by me to the house of accused Azhar. I did not state before police. This is important again, my lord, your lordship will kindly take note. I did not state before police that I saw wooden part of axe, bloodstained rope, and bloodstained cloth at the house of the accused. At page 140, my lord.
140?
140, my lord. First time in the doc, she said, I did not state before police. Page 140, about 5-6 lines. These are all after. I did not state before police, about 5 lines down. I saw wooden part of axe, bloodstained rope, and bloodstained cloth at the house of the accused. There was no previous dispute between the complainant and the accused person. It is not a fact that I falsely stated the name of the accused Azhar Ali Khan is involved in the LS crime. It is not a fact that the accused persons are not all involved in the LS. I did not see the dead body before recovery. The dead body was taken to Kalkapani market. The dead body was little decomposed. I did not see the incident of assault on the deceased. The accused person came to the house of the complainant, Nur Hussain Ali, in the morning of so-and-so. I went to the house of the complainant on the date of the incident. The bridge near Kalkapani is situated at a distance of 5-6 minutes walk from the house of the complainant. The dead body was found on the western side of the house of the Siraj. It is not a fact that police did not see bloodstained stick, bloodstained knife, and bloodstained fork from the house of Azhar Khan. It is not. These are all against suggestion. And again, it is not a fact that I did not state before police that there was profuse bleeding out of so and so, this, all this suggestions.
Again, out here, so again, she said that she has stated.
Yeah, but that's why we'll look into the IO statement, my lord. Your lordship will not take note of all these things. Because if you say that something has been seized first, your lordship, in the first part, she said, I did not state before police that I saw wooden part of X, bloodstained rope and bloodstained clothes at the house of the accused. Now, in subsequent, when the suggestion was made, of course, the suggestion was not at all required. It is not a fact I did not state before police that I saw recovery of bloodstained knife and bloodstained cloth at the house of the accused Azhar Khan. In the first, there is a positive assertion that she did not say. But when a suggestion was said, then it has been recorded as it is not a fact. So we'll look into how that was put to the IO, my lord, when you look at the IO statement at the last, my lord. Then your lordship will see PW4. All of them, my lord, one thing I find that all of them has said that Anar Khan and Sahar Khan took the deceased out from the house. And up to the bridge, my lord, those two witnesses are there. After that, my lord, there is no link. My nephew went to the, however, my nephew did not return back. Father of my nephew asked me the whereabouts of my nephew. Thereafter, I went to the house of Nazar Ali Khan and Azhar Ali Khan and told them about the incident. But the family of accused Nazar Ali Khan and Azhar Ali Khan told us that the sons and my nephew were not in the house. Thereafter, we were searching at various places. On the same day evening, one Farooq told us that one dead body was found in the southern part of the house of the accused Azhar Ali Khan. Accordingly, I and other family members went to the place where the dead body was lying. We identified as the dead body of my nephew Noor Alam. We saw a deep cut injury on the throat of the deceased and several grievous injuries on the body of the deceased. But this is again not supported by the medical report. I'll take the postmortem report. The lordship will find that there is only one injury in the neck. This witness has said we saw a deep cut injury on the throat of the deceased and several grievous injuries on the body of the deceased. Those are not there. Blood was oozing out from the dead body. Then the Azhar was written by one advocate, namely Islamuddin Ahmed of Dhubri Court. Accused Nazar Ali has got many antecedent of criminal case Nazar. Then your lordship will see cross-examination at 144. The dead body was recovered from a nala in Kalkapani Bazaar. There are about 150-200 shops in the bazaar. There is a bamboo bridge in the bazaar area. The weapons, axe, dagger, etc. recovered in connection with the alleged murder of my nephew are generally available in the households of the locality. Village area, mother. The shirt worn by my deceased nephew was seized by police today in the court. I have not seen the shirt. I cannot say how many shirts were recovered. It is not a fact that police did not recover axe, dagger, shirts, etc. from the house of the accused Azhar Khan. It is not a fact that the seized shards and weapons were not recovered in connection with this case from the house of the accused Azhar. And a suggestion was made at page 145 that it is not a fact on the issue of non-payment to the laborer. There was a vichar in the village and it a chain vichar. Nazar and Azhar were also present and they told us and they held us responsible for such illegal act. Now, page 146, PW5 is a short examination. Noor Alam's dead body was found floating in a stream. Page 146 is a short examination in chief. I know the complainant and the accused person. I also knew that this is Noor Alam. The occurrence took place about 3 years back. One day, Noor Alam.
No, there's no point reading the
Yes.
entire thing. You
Well,
put
that's-
the operative
so
question.
I'll take your lordship directly to those points which are page 147. Here, that Azhar's house, in the last line it is said, the dead body was recovered and Azhar's house is at a distance of 1 mile away from the place of recovery of the dead body. 1 mile. Now, at page 148, PW6, he says that on the date of the occurrence, dead body of Noor Alam was found in a paddy field near my house. And there was no implication of the present accused appellant. It's a short statement, only in recovery to the place of the dead body, only this statement has been recorded. Then PW7, he says, I went to do a fishing in a bill 149. I went fishing in a bill. While I was fishing, I saw human leg in the water of the said bill. I was scared and immediately ran away, came to the, told the people in the market that I saw a human leg in the so and so. So this witness said, North Stream bill. Then your lordship will
No, you
find,
see, PW says, basically, he did not see it. He only said when the body was brought to the market.
yes,
So
At
He
the-
he
my
does,
lord-
he does not know, he did not see from
Yes.
where it was recovered.
from the place, my lord, from the bridge, there is no evidence connecting directly to me. Now, so far the recovery of those materials are concerned, my lord, your lordship will kindly see the statement of the investigating officer, my lord,
Page
page 184. The IO who submitted the charge sheet.
Yes,
On 1/8/2014, I was posted as in charge of Bazaar TOP under Dhubri PS. On that day, I received a phone call from one Azhar Ali that one dead body was found in the bank of River Brahmaputra at Kalkapani, Part 2 village. Accordingly, I made GD entry number 14 dated 1/8/2014. I informed the matter to my higher authority and went to the place of occurrence to recover the dead body along with my staff. After reaching the place of occurrence, I found one dead body in the backside of Azhar Ali Khan in a jungle area. The dead body was identified by the Azhar Ali Khan as the dead body of Noor Alam. The dead body was recovered with the help of the local people. I noticed sharp cut injury on the neck of the deceased and one rope was tied in the neck. I accordingly inspected the place of occurrence and seized the said rope in presence of witness. I prepared sketch map of the place of occurrence. I also prepared scissor list. I recorded the statement of some of the witnesses. Thereafter, on being advised by SP and brought the dead body to Dhubri Civil Hospital and kept the same on the morgue of the said hospital. On the said next day, the inquest of the dead body was done by the executive magistrate in the morgue of the so-and-so. On that evening, the father of the deceased lodged an FIR. Dead body was sent for postmortem examination. This your lordship can omit, my lord. During investigation, I again visited the place of occurrence, recorded statement of witness. During investigation, I found that the deceased was called from the market in a pre-planned manner by Anar Khan and Shahar Khan. On the basis of the statement of the witness, I went to the house of accused and recovered one piece of wood with blood stain. I also noticed that the catch-up floor of the house was being cleaned and that it could be presumed that something had happened there. Then I inspected the entire area of the house of Azhar, found one narrow path towards the area where the dead body of the victim was recovered. I also noticed blood stain at various parts on the grasses and jungle in the narrow path. I also seized some of those grasses in presence of the witnesses. I recorded statement of witnesses. The accused persons were not found present in their houses. On 10/8/2014, I again visited the place of occurrence along with other police officers. I also engaged some source for collecting information. On 11/8/2014, the seized articles were produced before the learned Elakam magistrate and shown to him. On the same day, the seized article was sent to the FSL for examination. On 19/8/2014, I recorded statement of two independent witnesses on being produced by informant, namely Shorob Ali and Akhtar Hussain. The statement of the said two witnesses were recorded under section 164 CRPC. I have those statements. On 22/8/2014, the OC of Dhubri PS informed me that Anar Khan and Shahar Khan surrendered before the OC, and accordingly, I arrived and interrogated them. During interrogation, I came to know that both of them were below 18 years, and accordingly, they were produced before the learned Juvenile Justice Board Dhubri, and they were sent to the observation home. Thereafter, on 26/8/2014, they were reproduced before the learned Juvenile Justice Board Dhubri as per order. The other accused persons were not found in spite of charges. On 2010/2014, I collected the report from FSL Assam. The report of FSL revealed that the samples gave positive test for human blood. On 29/11/2014, I came to know from the order of the court that the accused Shahjamal Khan, Noor Islam, and Babu Khan surrendered in the court and they went to Dhubri jail. Thereafter, I interrogated the accused person in the Dhubri jail. On 15/12/2014, I received the postmortem examination report of the deceased. During the entire period of investigation, the accused persons remain absconded. Then, on being instructed
এই না তুমি
মই এটা কথা কওঁ, এই কেছটো
এনেই বিল বনা হয় ইমান নকৰো
তাক কানেক্ট কৰাটো একো নাই।
নাই সেইখিনি আৰু যিটো
কেনেকে
কৈছে
মই
নহয়।
এইটো ভাবি আছো। ব্ৰিজতে সেই
অ
তাৰপিছততো নাই আৰু এই দুটাক কেনেকে তুমি ভাবিছা? আৰু যদি
সেইকেইটাতো জুভেনাইল হ'ল
ঠিক আছে, জুভেনাইল হলেতো তাকে উইটনেছ বনাব পাৰিলো they could have made a witness. যদি মই মাৰিছিলো না তাহাঁতকতো
they are the accused.
I mean, rejected, dismissed. No, what? No, what theory? There's a return. Decada. Decada.
Yes, sir.
Decadas rejected.
yes,
Yeah.
Appeal.
Appeal is rejected. How do you suppose?
No, sir.
So basically, my lord, there are 20 prosecution witnesses and one court witness. The court witness was brought into place because to prove the statement recorded under 164 CRPC. But now that has
Who's
no,
164 statement?
well, two of the witnesses were recorded. But now that is will have no meaning because it can at best could have been used as a contradiction or corroboration. So that's why I have not even taken your lordship to the 161 statement. But out of curiosity, I just checked just now along with my friend, the 161 statement. All the statement of these weapons and all were made first time in the dock. The ideal situation would have been, my lord, the contradiction in terms of section 45 of the 145 of the Evidence Act, along with 162 of this CFC, that process ought to have been followed. But I am quite surprised, my lord, your lordship has seen day in and day out. Even this elementary rule of proving the contradiction has not been followed in the courts below by the councils. I don't blame my brother because when we are in law college also, we are
You
not.
don't blame them directly, you
uh,
blame them indirectly.
Yes, madam. Because when we are in law college, madam, we are not taught how to prove the contradiction in practical life. Now, when we start learning or studying by ourselves or by observing others, then we learn that if you in the contradiction, if you don't put it within inverted comma, those contradiction and bring it to the notice of the witness, we cannot use it during a criminal appeal because that foundation has to be given during the trial. So at this stage, what I can only say that these weapons which or the bloodstained clothes or the scissor they are talking, these are not on record. The grass also, the grass that has been mud along with the grass that has been seized, it talks only about a human blood group AB. But you have to connect that blood with the disease. That these are now if the investigating authority doesn't do it, whether it is deliberate or unintentional, I don't know. If you don't do it, then how do you prove a case of 302 in the court? Similarly, if you seize the clothes, you have to send the clothes to the FSL for examination to see whether the blood or anything that is found in the cloth, that is also not there. Similarly, certain exhibits have not been shown to the court also, madam. So in spite of all this, madam, the two persons who took out the deceased from the home up to the bridge, they later on appeared to be juvenile. So they have been acquitted. Now someone,
Acquitted or sent to the.
but juvenile justice board, so they cannot, they are not, they cannot be arraigned as an accused in this case before the session trial.
And what was the final decision?
And so far they have to find someone because ultimately one person has died. So, and even in the evidence, whether other persons were living in that house along with Azhar, whether Azhar was, those evidence are also not there. And even in the name also, Azhar Ali Khan, it is all along, I have checked in the 161 statement and all, it is all Kha. So there must be also an effort from the prosecution or from the defense side also that this Azhar Ali Khan and that Azhar Kha is a different person because the name also doesn't matches. So prima facie, I feel, my lord, that this is a case where lordship may consider the bill at this stage. At the final hearing, my lord, if your lordship finds from looking into all the evidence that then your lordship may pass the judgment accordingly. But to keep him in custody, subject to what my learned friend says, I don't find, my lord, any evidence to connect this person with this offense of 302. And even the learned session judge has also observed in many of the paragraphs that this, why the police have not done it, whether it is intentional, unintentional. So many gaps are there. And in the case of circumstantial evidence, if you don't do the scientific investigation properly, it is difficult, of course, but sometimes your lordship may not believe the medical evidence and will go for ocular evidence. But when the ocular evidence of all the relationship, I've given all the relation there for the first time in the court, they have come and said all those things. And moreover, my lord, even the IO was also not confronted properly, but we have to go whatever evidence is available on the record. The prima facie is satisfied that this seizure list or the scientific evidence, and even in the postmortem report also, some of the witnesses have said many grievous injuries are there. I find 2 injuries. One is on the neck with a sharp weapon. It's not the rope, my lord. They say it's a sharp weapon. And there is one contusion, small contusion in the arm, my lord. And that is clinically very insignificant because it is just 3 centimeters and 2 centimeters. So only one injury is on the neck. So my humble prayer at this stage is that your lordship will kindly consider the bill. When the appeal comes, my lord, we'll examine more detail into all the aspects. And if there is any scope of upholding the conviction, your lordship will uphold them. But now, my lord, I pray, my lord, that he is in custody. So your lordship may consider. And surprisingly, again, another thing I have noticed. Well, on the day when this person along with another person was shown as an absconder, he appeared before the judicial magistrate first class and says that I have received the summons and I have appeared. And the ground taken was that no effort was made by the police to look out for me. So I did not come and appear before the IO. And on day 1, my lord, the judicial magistrate first class granted the bail. And that also, my lord, because as an officer of the court, I have seen from the record that earlier anticipatory bail was moved and it was rejected. But when you appear before the court also, my lord, when you appear before the judicial magistrate first class court, after the charge sheet has been submitted, at least you could have looked into the record, or on day 1, my lord, without looking into the record also, that he has been granted bail. So those are the things I have just brought it to the notice, my lord. But prima facie, it appears, my lord, that this person cannot be connected with this offense of 302. That's my humble prayer before you.
The evidence that are there on record, like what the fact, what the these 2 boys were taken first, this is from its place, saying that it was the applicant who had called. So, and this was the first evidence, it is the circumstance. And second is 164 statement, PW 12 and 9 said that they saw these 2 young boys taking the disease because of that is only once. The trial statement, it's not there. So he had seen taking the disease to the house of the applicant. Body was found next day. And of course, everyone would say a different place, but then the place is same, they are saying it from different directions.
Different angles.
Different angles. So it amounts to saying that it was at the backside of the applicant. And there was.
Not backside of the applicant, back of the applicant's house.
Back of the applicant. So,
When you start saying backside,
back of the applicant's house at the rear side. And then there was a tributary or a pond and a water body. There it was fine. And then there were some blood stains there at the backside of his house.
again, backside of his house.
Again, backside of the house.
Say back of his house. When you say backside of his house, where's the question of backside being there is when you refer to a house.
Yes, I said back of the house.
Hmm.
Then again, those things which are recovered, the stick. I'm not going into the machete and all, or some bigger. It's a stick, some grass, and one
No. What does the medical opinion say? What does the medical doctor say? Does he say that it's caused due to a sharp weapon? Or due to, if it's a sharp weapon, it cannot be a stick,
Cannot be a stick.
then
And they have also recovered a rope. But rope again.
rope again doesn't, there's no sign of strangulation, then no seizure.
No seizure.
There is a seizure, there's seizure of a rope.
Uh-huh.
I think rope was seized.
Rope.
Rope was seized, rope was seized, stick was seized. Huh?
Rope and stick,
No, rope.
Exhibited.
Exhibited.
Exhibit. Material exhibit.
page 88, page 88,
Page 80. It is there.
yes,
Rope is there, grass is there.
grass is there.
Rope along with
Blood stained grass is not there, only grass is there.
grass. But then blood stain was found AB positive.
But is the disease AB positive? No.
The linking part is not.
And my lord, you're also surprisingly,
Just a minute.
And then,
one
he
sixty-four,
was not found, it not be arrested for the funding. Then of
So-
course, he surrendered, he himself.
Look,
appeared.
there are many circumstances which appear suspicious. No doubt about it. And the problem is that we cannot, base our final decision on the basis of speculation or suspicious character of a person, or his actions. That is a problem.
Complete.
even 164 statement was not exhibited. my
Okay,
lord.
we'll allow, okay, right. Heard. Miss, Leading for
164 to exhibit to bill.
learned counsel for the, learned senior counsel for the applicant. Also heard Miss El Jahan, additional PP. This application under section 389 CRPC has been made for suspending the sentence. The sentence requiring the applicant to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, in default to undergo simple imprisonment for 3 months. Pursuant to the impugned judgment and order dated 8/6/2023 passed by the Court of the Learned Additional Sessions Judge, Dubri, Assam, in Sessions Case number 286 of 2015, whereby the applicant has been convicted under section 302 IPC. Mr. Yes, Mr. No problem, no? No problem. Next. The applicant's counsel submits that the evidence of the prosecution witnesses nowhere indicates the involvement of the applicant in causing the death of the deceased. He submits that though the prosecution witnesses, though some of the prosecution witnesses had stated in their testimony
One 130, my lord.
had stated in their testimony that the police had recovered 1 axe, 1 rope, 1 blood-stained knife, blood-stained cloth, etc. from the house of the applicant, no axe, blood-stained knife or blood-stained cloth had been produced or exhibited before the learned trial. He also submits that though the police had seized some blood-stained grass and exhibited the same, the police had not been able to connect the blood found on the grass with the blood of the deceased person. He submits that the seizure of the seizure of the rope by the police does not have any relevance, in as much as the deceased had died due to injury caused by a sharp-edged weapon, as per the opinion of the medical doctor. What else have you stated? What are the other, what are the other?
These are sufficient, my lord, because next shaft weapon it is same, but it is not low.
Stuff. He also submits that though some of the prosecution witnesses had allegedly stated that the deceased was to be taken to the house of the applicant, there is no proof that the applicant had been taken to the house of the applicant. Next, that's all.
That's all, my lord.
Next para. Miss S. Jahan, learned additional.
Or your lordship may add one more, even the 164 statement was also not exhibited before the court.
Who's 164? 9 and 13.
Yes.
9
9
12.
and
He also submits that though PW 9 and 12 had given their confessional statement,
not
had given the
160
statement,
164.
had given their statement under section 164 CRPC to the effect that they want
To the effect that no, no,
to the effect that what?
that Shah Khan have taken away the deceased Nuram, stating that he was invited at Azhar Ali's place.
To the effect that the deceased had been invited to the house of the applicant, the said statements had not been exhibited during trial. Next para, Miss L. Jahan, the additional PP, on the other hand, submits that PW 1 and 2 in their evidence had stated that the deceased had been asked to meet the applicant. Further, PW 12 had stated that he had seen the deceased being taken towards the house of the applicant. Full stop. The body of the deceased was found in the back of the house of the applicant. And no explanation for the same had been given by the applicant. As required under section 106 of the Evidence Act. Anything else? We have heard. We have heard the learned counsels for the parties. We have noticed that though there had we have noticed that though the testimony of some of the witnesses is to the effect that blood-stained knife, an axe, and a blood-stained cloth has been recovered from the house of the applicant, no such materials had been produced before the learned trial court, nor had they been exhibited. Pushpa. Without going too deep into the evidence adduced by the prosecution witnesses, because if we go too deep, then it will basically will be demolishing the entire case. Without going too deep into the prosecution, without going too deep into the evidence, comma, we also find that.
Your lordship may hold a prima facie view at this stage, not.
We are of the view that that the that the that prima facie the appellant has made out a case for suspension of the sentence imposed upon him. Consequently, we are of the view that consequently the sentence imposed pursuant to the impugned judgment and order dated 8/6/2023 passed by the learned trial court in sessions case number 286 of 2015 is hereby suspended. Consequently, the applicant is allowed to go on bail on a bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the learned
Additional session judge Duburi.
additional session judge Dubey. The IA is accordingly disposed of. Then in the main appeal, you write, as LCR has arrived, registry to prepare the paper book. Is it required? Waste of paper.
But it's not required. I have given the entire evidence because nowadays whenever I file a criminal appeal, I try to give it, not required, madam.
That is one thing is that not man, but one thing is that it should be verified by them.
Yes.
Yeah.
But I have in
But
my.
he has given the paper, it's a waste of paper actually. Yes. Original is there.
Original is
Yeah, because I mean, there's nothing much.
minimum it will become disbursed, madam. Minimum.
Ah,
This is
right,
around,
right, right.
this is around
Mr.
200 pages.
PD Kumar appears for the appellant. Ms. S. Jahan, additional PP appears for the state. The parties submit that the matter can be heard on the basis of the appeal petition filed by the appellant. And the same can be cross-checked with the LCR which has arrived. Accordingly, this matter for hearing in usual court.
Thank you. Thank you.
Bye bye.